Hello everyone and welcome back to the lecture series for the preparation of CLAT examination. In this particular lecture series, we are actually discussing about the legal reasoning portion, which is an important part of your CLAT syllabus, which has been designed and provided by the CLAT consortium. In the syllabus, they have described that there are various legislation which a CLAT aspirant is supposed to go through and understand, and that is perhaps the reason why we have made these particular lecture series. And in this particular series, regards to the legal reasoning portion of your CLAT examination, we are pretty much focused over the important major legislations which ought to be asked in your CLAT examination. And throughout this lecture series, we have been able to complete various chapters, which includes the law of torts, the Indian Contract Act, the Indian criminal laws, the Constitution of India, and the family laws also. In this particular lecture series, we are perhaps going to complete the important provisions of the Constitution with the part 20 of the Constitution, which talks about the amendment of the Constitution. And why is it important? Obviously, because it is going to be asked in your CLAT examination, first thing. And second thing, as a layman also, it is expected that the person should have knowledge how the Constitution is going to work. And apart from that, how the Constitution can be altered. So you must have seen that there are various speculations in the society that a government has this authority to change the legislations, and the government can change the structure of the Constitution also. So in order to understand that how the Constitution can be changed, or whether the whole Constitution as such can be changed or not, the first and the foremost thing that is important for any of the CLAT aspirant is to understand that when you talk about, I suppose the screen is visible to you. Yes. And yes. And when you talk about amendment, what does amendment means? Amendment actually means alteration. Alteration. Second, it can also mean addition. It can also mean deletion, etc. Addition, deletion, alteration, modification of the Constitution can be done by following the procedure that has been enumerated under part 20 of the Constitution, which actually talks about the amendment of the Constitution. But first we need to understand that when we talk about amendment procedure, what exactly do we understand here? That this is a procedure which will alter, add, delete the provisions or modify the provisions in relation to the Constitution as such. But there is a concept that we need to understand here, that whenever we are talking about amendment as such, whether the whole Constitution as such can be changed. Question is whether the whole Constitution can be altered. Can we change the whole structure of the Constitution? Can we remove fundamental rights? Can we remove the directive principles of state policy? Or can we change the amendment as such? Can we change how the process of the amendment needs to be done? All these things has been enumerated and been answered under the part 20 of the Constitution, which is the amendment procedure. And the most important point when we talk about this question, that is whether the whole Constitution can be altered, first we need to understand that there has been a lot of truffle between judiciary, and the Constitution. Judiciary and the union government. And why is it so? I'll just let you know. Union government. And this is something which has been happening from a very long period of time, and it is something which both the organs of the government, you know that there are three organs of the government, correct? One is the judiciary, second is the executive, that is the government, and the third one being the legislature. The legislature, meaning which the Lok Sabha and the Rajya Sabha. When you talk about the union as such. So every time all these three organs have their different roles and importance. But there is always a tussle between the judiciary and the government, where which both of them, both the organs, wants to have a sort of a superiority towards each other. The judiciary wants that the constitution should be kept intact, and on the other hand, the government believes that the constitution should, being a dynamic document, and it should be according to the needs and the requirements of the people. They want that the provisions can be amended and altered. So there has been a tussle between the union government as well as the judiciary whenever the provisions of the constitution has been often mentioned. So the problem here is that judiciary has clearly said by different case laws, okay, the different case laws, that the constitution in itself can be changed, but it cannot be changed to that extent where which the basic fundamental features of the constitution can be altered. Now, what all are these basic features? First, we will try to understand it so that it becomes a clear understanding that what exactly that can be changed according to the judiciary. I'm telling, according to the central government, everything can be altered. The government can change the provisions of the constitution. They can bring the legislations telling that, okay, this particular portion needs to be altered, this particular provision of the constitution needs to be altered. But if you remember correctly, if we understand the essence of the constitution and we try to analyze that what exactly the minds of the constitution makers who were actually drafting the constitution wanted to tell about the constitution as such, is that by the virtue of Article 32, if you remember correctly, Article 32 prescribes that the judiciary, okay, the Supreme Court is going to be the guardian of the constitution. So when you say the guardian of the constitution, mean it is the responsibility of the judiciary, an organ of the government, to safeguard that the constitution, the intention of the constituent assembly to formulate a constitution which is for the benefit of the society should be kept intact. And that is why judiciary always have an intention to create the laws and to amend the laws in such a manner that the basic structure which has been enumerated in a case law. And for this, we will have to understand the whole mechanism of what exactly is the basic structure, how the basic structure works. But for your understanding, as of now, all you need to understand is that there was a case, the case of Keshanan Bharti versus State of Kerala. Okay. State of Kerala, 1973. In this particular case law, so there was in the history also, there was a tussle that was going on between the union judiciary and the government. The government were bringing laws which were, when scrutinized by the government, by the state government, by the judiciary, it was clear that there was certain provision that was created by the government which were against the provisions of the constitution. And by virtue of Article 13, if you remember, when we were studying about the fundamental rights. So Article 13, what does Article 13 says, guys? What does Article 13 says? Article 13 says that any act or law which is inconsistent or in derogation with this part, that is fundamental rights, shall be considered null and void. So it said that whenever you're talking about any act or law which is in derogation or which is conflicting with the provisions of the constitution, where which the basic structure, there is a concept that was given under the case of the Keshavan Bharti versus State of Kerala, that is a basic structure doctrine. And we will understand what exactly is the basic structure doctrine in a very detailed manner. But for you, as of now, in order to understand what exactly amendment is, I am just giving you a brief background so that it becomes easier for you to understand that what exactly, why is it so, and how is it so that the constitution can be altered or can be amended. But it is not like that the whole constitution can be amended, or is it possible that the whole constitution can be amended? This is the question that is in front of us right now. So obviously in the previous year, when the judiciary came into force in 1860, and then there was numerous judgments that was passed. Amongst those judgments, there was a very famous judgment, and that judgment is the Keshavan Bharti versus State of Kerala, in which the constitutional bench. So the constitutional bench was there, which was set up in order to discuss this case. And in that particular bench, the concept of basic structure came into being, which said that a constitution in itself can be altered. There is nothing wrong in altering the provisions of the constitution. But there are certain things or certain essential elements in regards to the constitution that if at all they will be amended or altered, it will lose the authenticity or the importance of the constitution as such. The words that were given, so there were some things that were enumerated by the judges of that constitutional bench, which remarked that democracy being one of the part of the basic structure, the federalism being one of the part of the basic structure, and there are other provisions which are part of the basic structure. If at all, these basic structure doctrine, if we talk about these basic structures, the constitution should be altered and amended in such a manner that although you can change anything, it's not like that you cannot change the fundamental rights. You cannot change the directive principle of state policy. You cannot change the preamble. You can change almost everything. You can change the fundamental right. You can change the directive principle of state policy. But whenever you are changing it, you have to keep in mind that you are not altering the basic structure of the constitution. So for example, if you see that whenever there is a construction going on and whenever we make a house, okay, so a house can be modified. The inner portions can be modified in n number of ways. You can change the color, you can change the design, you can change the structure, but the pillars which are supporting the house as such, which is giving it strength, that never gets changed. The beam of the structure never gets altered. So in the same way, judiciary wanted that there should be a mechanism and there should be certain provisions, or if I will say the doctrines or the principles, which should never be altered, which forms the basic structure of the constitution. And this was what was given under the Keshavan Bharti versus State of Kerala. So if we try to analyze and understand whether the whole constitution can be altered, the answer would be yes. The whole constitution can be altered, but leaving the basic structure aside. Leaving the basic structure aside. Meaning which the whole constitution can be changed, but leaving the basic structure aside. So it means that the constitution can be altered, but not the basic structure. Not the basic structure. So apart from the basic structure, you can change the constitution as such. And that is why it becomes important to know and understand that how the procedure will be made, on how the process of the government or the judiciary, who is actually empowered to change the constitution as such. In this particular video, we are going to understand that how the constitution can be altered or amended. What exactly is the procedure? And in the upcoming video, we'll try to understand what exactly is the basic structure and what are all the things that has been included in the basic structure which cannot be altered. Okay, so that is why it becomes important for you to understand the procedure, because when you talk about your CLAT examination as such, they will be asking you questions on the procedure on the procedure of the amendment also, and obviously this question which is in relation to the basic structure, that whether the whole constitution as such can be altered or not. So for that, it is required to understand first the procedure and then what exactly can be changed and altered. If you talk about the basic structure as such, we will be discussing around 6 to 7 case laws which encompasses in regards to the basic structure doctrine, and it all started with a question of whether the preamble is a part of the constitution or not, and then perhaps after that the basic structure doctrine came into being. So we will understand it and we will correlate it with the amendment so that you can understand that what exactly are the procedures, what exactly are the provisions which can be altered and which cannot be altered. So basically almost all provisions can be altered, but the essence of that particular provisions, if it is touching the basic structure, shall not be entered. I'll give you an example for your better understanding. That for example, if you will say that everybody in democracy, everybody has the right to vote, correct? So when you talk about democracy and everybody has the right to vote, then the government cannot make or bring any law which is in derogation or which is inconsistent with the basic structure, saying that only a particular sect of the society is entitled to vote. The first reason is obviously it is going to be against the provisions of the fundamental rights, that is Article 14 and right to equality. And apart from that, it is also going to encompass the basic structure, because when you see the list, and the list has been not created and not exhaustive as such, it is through the different judgments that we were able to understand that what exactly are the things that can be considered to be the part of basic structure, and what are all the things which are not considered to be a part of the basic structure. And obviously when we were talking about the tussle that is going on between the judiciary and the government, it is not like that the government is not the government stopped at this point of time. After the incorporation of the basic structure doctrine and seeing through it that okay, there are certain provisions which the government as such cannot make, which is going to hamper the constitution, the essence of the constitution. So through the legislations as such, the government and the case law, which is IR Coelho case law, we'll be studying that case also, that there is certain provisions which, if enumerated by the government in that particular list, that list, if there is an act which has been incorporated in that particular list, the list that has been provided in Schedule 9, that list, if that list has any act, and that act cannot be questioned or judged by the judiciary as such. So what it did was that it refrained certain acts which the government feels like that these acts are important acts and there shouldn't be any questioning over these acts by the judiciary as such. That act will not be questioned or put up in front of judiciary. But if any of the provisions of these legislations also, the acts which has been enumerated under the Schedule 9, which cannot be called in question by the judiciary, but if at all this touch the basic structure, if at all they are going to alter the basic structure, then they will be considered to be questionable in the court itself. Okay. So obviously there is a tussle between the judiciary and the government, and that is why in order to balance it somehow there is a compromise that both the organs of the government takes against each other, and this is how the balance has been maintained. So let's try to understand what exactly is the procedure. we'll go through the provisions of the Constitution, that is part 20 of the Constitution. And in that particular part, there is perhaps only one article that is going to be discussed, and that is in regards to the amendment of the Constitution. Okay, this is chapter 18, which is talking about Article 368. Article 368, let's try to understand. It is saying power of the Parliament to amend the Constitution and the procedure thereof. Okay. So first thing was procedure for the amendment of the Constitution. It was changed, and now this is new heading which has been incorporated. Now question is, why is it so that the name has changed from procedure for amendment of the Constitution and then to power of the Parliament to amend the Constitution and the procedure thereof? The reason is obviously, which I told you earlier, that there is a tussle that is going on between the judiciary and the government. So when you talk about the power that has been given to the Parliament, so Parliament, it means that the Lok Sabha, Rajya Sabha, and obviously the President. Correct? So when you talk about the Parliament has been given power to amend the Constitution. Not the judiciary, but the Parliament. And this Parliament has to work according to the procedure that has been provided under Article 368 to amend the Constitution. Power of the Parliament to amend the Constitution and procedure thereof. Now, okay. Now the first, let's try to understand what exactly is the first provision saying. It is saying, okay. The first article of the Constitution, the first clause of Article 368, which is talking about the amendment, is saying that notwithstanding anything in this Constitution, Parliament may, in exercise of its constituent powers, the powers that has been given by the Constitution, amend by way of addition, variation, or repeal any provision of this Constitution in accordance with the procedure laid down in this article. So I suppose this is very much easily understandable, and there is nothing confusion, or I suppose the candidates will not be able to understand that it is just saying that the Constitution, in notwithstanding anything in the Constitution, means that even if there is anything written, okay, in the Constitution, it is only the Parliament may, in exercise of its constituent powers. So it is the power that has been given by the Constituent Assembly to the Parliament, amend by way of addition, variation, or repeal any provision of the Constitution in accordance with the procedure laid down in this article. Okay, so now let's understand. We understood that it is the power that has been given to the Parliament by the way of constituent powers, and to add, vary, or repeal any provisions of the Constitution, and it should be in accordance to the procedure laid down under Article 368. Now let's try to understand what this article says. An amendment of this Constitution may be initiated only by the introduction of a bill for the purpose in either house of the Parliament. So the first thing, whenever you want an amendment to be done, what is the first step? The first step would be introduction to a bill. Now what exactly bill means? A bill is an intention or a government move to show to the Parliament, that is the different houses, the lower house and the upper house, that we want to make any alteration or we want to change anything. So it is a sort of a bill, an initiative, I would say, for your better understanding, an initiative that the government wants to take or the Parliament wants to take in order to make changes. Okay, and by the introduction for the purpose in either house of the Parliament. So either house of the Parliament, introduction to the bill can be in the Lok Sabha as well as in Rajya Sabha. For what? For amendment procedure. and when the bill is passed in each house by a majority of 2/3 membership of that house and by a majority of not less than 2/3 of the members of that house present and voting. Okay, so now the first thing is obviously introduction of the bill. It can be made either in Lok Sabha also, and it can be in Rajya Sabha also. It can be anything. And how the bill is passed, whenever the bill is introduced, how the bill will be passed. So it will be passed. The second step is the bill will be passed in either house by a majority of 2/3 membership. Now let's take the example again. There are 500 membership in a particular house. We divide it by what will be 2/3? So its 2/3 will be 666, almost around. Okay, there will be 1000. It will be around 335. Okay, let's take the example that there will be around 335. So this will be around 2/3 of the members. So if their house is 500, then 2/3 of 500 will be considered a majority. That is the total membership. So there are two ways. The first, you need to understand that there are 500 seats in one house. Okay, and there are 500 members who are going to represent a particular area in that particular house. And obviously it cannot be made possible that every person who has been elected the member of parliament be present in the particular session, whenever the session has been there, whenever the introduction of a bill will be there. There are chances that somebody might be for doing some work, might be ill, might be involved in some other task. So it cannot be 100% attendance in regards to the houses. So the first requisite is that if their membership is 100, then 2/3 of that membership, meaning which 2/3 of that membership would be if we talk about 3, there are 3 members, so 2/3 will be 2. If we talk about 300 members, then 2/3 will be 200, right? So if we talk about, let's take an example, because mathematics is something which I am not that much capable, but still I'll try to make you explain better so that you can get a better understanding. So if you talk about 2/3 of 300, it amounts to 200 seats. So first, if there are total membership is 300, so you need at least 2/3 seats, 2/3 majority. So you need at least 200 plus votes to introduce a bill in the house. And once the bill has been introduced in the house and it is approved by 200 plus votes, who are actually the majority of the total membership of that house, plus there is addition of it. One requisite is that there should be at least 200 plus votes to support this claim that yes, the introduction of this particular amendment is approved by these members of the parliament. And then if there are, let's take example, there are 300 total number of seats, and out of those total seats, there are only 200 members who are actually present right now. Okay, or rather, we can say it 150 members. Okay, so 150 members are present there. And out of those 150 members, if we talk about 230, then it will be 100. So if there are 100 members who are present, okay, so out of 300, let's take an example that there are 200 members present. Okay, 200 members are present who has given their approval. And out of these 200 members who are present, 2/3 of those membership should vote for the approval, that are present and voting. 2/3 of the membership who are present and voting, it will amount to 100 votes. So 200 votes which are going to support. Let's try to understand it again. Amendment of this constitution may be initiated only by the introduction of a bill. The introduction of a bill where which it can be in the Lok Sabha also and it can be Rajya Sabha also. in the parliament. And when the bill is passed in each house, how the bill is supposed to be passed in each house? By a majority of 2/3 total membership of that house, and by a majority of not less than 2/3 of the members of that house present and voting. So let's remove this and let's try to understand it again, so that you people have a clear idea that what exactly the procedure talks about. Okay, so the first thing is majority vote. So now there are 300 members, total members. There are maximum seats of a house. Okay, and what will be a majority? If we talk about simple majority, it will be 150 plus 1. So there will be 151 votes. So you got 151 votes, which is majority of the total membership of the house. Out of these 300, only 200 members are present. Okay, and out of those 200, 151 people have approved, or even if there might be some members who are not present, but they still want that there should be approval in regards to this amendment, they have given their approval. And now there are 180 members, let's take an example, 180 members who are present in that particular house at the time when this particular bill was introduced. So out of this 120 members, the 2/3 majority, so 2/3 majority will be 120. So 120 of that particular membership, okay, and by a majority of not less than 2/3 of the members of the house present and voting. So there should be at least 120 plus members who were present and were voting, and apart from that, there are a majority of the total membership of the house who is the maximum number of the house. If both combined allows that particular bill to be passed, that bill will be considered to be passed by that particular house. Meaning which, if the bill is introduced in the Lok Sabha, then if the Lok Sabha total membership is 500, then the majority will be what? Majority will be 251, and 251, and suppose out of those 500, only 200 are present. So if we divide it by, let's take the example, 300 are present. So if we divide it by 100, then it will be 200 members. So 251 members have approved that, okay, the bill should be introduced and passed out of the total membership, that is 500, and the members, the 200 members are present in the house who are supporting the claim that yes, we want this bill should be passed, and they voted in favor of this particular amendment. Then the amendment will stand passed from that particular house. So this is how the bill, once introduced, will be passed in that particular house. So whether it will constitute that amendment is completed? No. This is only a 50% part. Now that bill, after being passed by one house, shall go to the other house. Article 368. Okay. This is for it shall be present to the president, who shall give his assent to the bill, and thereupon the constitution shall amendment according to the terms of the bill. Okay. So this is talking about so after this, once the bill is passed from the Lok Sabha, then if it has been introduced in the Lok Sabha, then the same procedure shall take place in the other house. Okay, and the same procedure shall take place in the other house. And when that same procedure shall take place in the other house, and once the bill has been passed from that house also, then it will go to the president. It will go to the president, and the president, when it is presented to the president, who shall give his assent. Who shall means, shall here means it is compulsory. Compulsory for the president to give his assent. To give his assent to the bill, and thereupon the constitution shall amended in accordance with the terms of the bill. In accordance with the terms of the bill. How the terms of the bill has informed that this particular amendment needs to be altered, that particular bill will change according to that particular requirement. And once the bill has been signed by the once the president gives his assent by signing it, that bill will become an act which has amended the provision of the constitution. Okay, so this is how the procedure is in regards to the change in or alterations of the provisions of the constitution. But there is a slight change that also we need to understand, that whenever there has to be any changes that has been provided under article these, which has been mentioned here, article 54, which is talking about the elections of the president, then article 55, which is talking about the manner of election of the president, then article 73, which is talking about the council of ministers, then article 162, article 241 to 79, and 279A, which has been inserted and substituted by 101st amendment. And then if all these articles needs to be changed, the amendment shall also require, apart from that, Lok Sabha and introduction in the Lok Sabha and then being passed by majority and 2/3 majority and not less than 2/3 majority present and voting. Apart from that, and both the houses needs to pass it. But if there is an amendment that needs to be brought under article 54, 55, 73, 162, 241 or 279A, then in that particular matter, it shall also be required to ratify by the legislatures of not less than 1/2 of the states. For example, if India is a union territory of 20 states, then 1/10 of those states will be how much? 2 states. Okay, so at least 1/2. 1/2 means at least 10 states ratify 1/2 of the state by resolution to that effect, passed by those legislatures before the bill making provisions for such amendment is present to the president for his assent. So this will also require 1/2 resolution or ratification, or means acceptance by the legislatures of those particular states. So if there are 20 states in a country, in India, if there are 20 states, 10 states should ratify that yes, we want this amendment to take place, and then only the provisions which has been enumerated under article 54, 55, 73, 162, 241 or 279A can be altered. Okay, nothing in this article shall apply to any amendment made under this article. Nothing in article 13 shall apply to any amendment made under this article. Meaning which? What does that mean? It means that if there has been any provision which has been meant that is contrary or in derogation with the fundamental right, nothing in article 13 shall apply to any amendment made under this article. So if there is any amendment that has been brought about, it will not say that it is, since it is in derogation with the fundamental rights, it cannot be enforced. Reason being, if we see this amendment as a law which is against fundamental rights, then by virtue of article 13, it shall be what? Null and void. So the main objective of changing or altering the provisions of the constitution will not be able to be effected. So that is why whenever there is an amendment that has been brought up through the process which has been enumerated under article 368, if that procedure has been followed and everything is fit and fine, then it will not be considered that it is in derogation or it is in conflict with the fundamental rights, and that thus this particular law will be considered as null and void. So amendment as such will not be considered to be null and void just because they are falling under the category of article 13. Okay, so that is why it has been mentioned in Article 3. And if you go through Article 13 and the 13 subclause 4, you will find the same mention that nothing in this Article 368 shall apply to any changes that has been brought under this article. Okay, now what is the fourth one? No amendment of this constitution, including provisions of this 3, made or purporting to have been made under this article, whether or before the date of the commencement, okay, shall be called in question in any court on any ground. Okay, no amendment. Now this particular thing has been changed. Okay, invalid by the Supreme Court in Minerva Mills and others versus Union of India. This is what I have explained it. So this has been removed. So now obviously it can be brought up in question. For the removal of doubt, it is hereby declared that there shall be no limitation whatsoever on the constituent powers of the Parliament to amend by way of addition, variation, or repeal the provision of this Constitution under this article. Under this article, but subjected to basic structure doctrine. Understood? So this is why it becomes very important for everybody to understand how the procedure in regards to changing of the constitution works. Now when you talk about amendment as such, so please understand that there is a difference between amendment of the constitution and making a law. There are two different things. There are perhaps 3 ways by which a change in the constitution can be made. The first is by simple majority. Okay, then you have special majority. Okay, so the special majority you have just understood. Okay, that special majority is something which whenever we are talking about amendment of the constitution. But when there are things which requires a simple majority and the provisions can be altered, then it can be done very easily without any special majority that is needed. But whenever there is special majority that is required, whenever there is a need to change the constitution structure as such, then at that point of time the special majority is required. Special majority has been mentioned under this particular article. Okay, so there will be a question that will be put up in front of you, and that is that if you want to change or alter the conditions or alter the size of any state, what type of amendment would it be considered? Whether it be simple, whether it requires simple majority, special majority, or special majority along with ratification of state. Student gets confused because they feel that okay, it is such a big issue that we will be changing or altering the societies as such. Then obviously there will be a requirement of special majority. But the answer is no, only a simple majority, and by initiation of a bill which requires in regards to the changing of the constitution, it can be changed because it is nothing to do with the constitution provisions, but rather altering the structure of a particular territory. Okay, and there are small things that will be changed in the state schedule, but not the provisions of the constitutions as such. So whenever there is a need of changing any provisions, okay, see, if you can understand it another way, notwithstanding anything in this constitution, Parliament exercise amend by way of addition of the any provisions of the constitution, any provisions of this constitution. Okay, and amendment to this constitution can be brought by 2/3 majority. Okay, so that is why it is important for you to understand about the simple majority, special majority, and special majority with ratification of state. So whenever there is a need to alter the society, alter the boundaries of a particular state, for example, Uttarakhand was carved out from Uttar Pradesh in the year 2000, and now there are 2 states. One is Uttar Pradesh and one is Uttarakhand. The same way, Chhattisgarh was taken out from the state of Bihar, and Jharkhand was also taken out from the state of Bihar. And that is why it becomes important for you people to understand that it doesn't require special majority or ratification by state, but rather requires simple majority, because this is a particular question that has been asked and put up in front of the CLAT aspirants whenever they are going to answer and approach this particular type of situation in regards to amendment procedures. So with this, we have concluded the amendment procedures as such. In the upcoming video, we are going to discuss about the basic structure doctrine, and post understanding what exactly is basic structure doctrine, we'll be discussing some important case laws that are going to be there in your question paper, and which will be helpful for your better preparation in regards to your CLAT examination. And it will be beneficial for you not only for a CLAT examination but for your future growth and in career also, because that is something which is being asked not even only during the your college, but also after completion of your college years, and when you start your real time practice, or if you wish to prepare for judiciary, or if you wish to become a lawyer, then also it is perhaps very important for you to understand what exactly is basic structure doctrine and how this doctrine evolved. What are the things that has been included in the basic structure doctrine, by which case law that the particular doctrine, but particular feature of the constitution has been considered to be a part of the basic structure doctrine. All these things we are going to study in our next video. With this, I would like to thank you all, and I would like to inform you that with this we have almost completed the provisions of the constitution, the important provisions of the constitution in relations to the CLAT examination, and we will be obviously going through in a very short, crisp and precise manner what exactly is the basic structure doctrine, which will put an end to the whole syllabus of your constitution. And with this, we will be moving forward to our second last lectures over the international law, being an important part of your CLAT syllabus in regards to legal reasoning also. So we will be going and understanding the international laws, and we will start with the United Nations Charter. We will understand what exactly how the United Nations Charter, first we'll try to understand the brief history, that how the United Nations Charter actually came into being, what is the relation between World War and the formation of the United Nations Charter, and what exactly is their principle, and what exactly are their goals. After understanding it, we will try to understand its organs and what exactly are their functionings, and post that we will try to understand some specialized agency which has often been asked, that what exactly is their work and what exactly they are supposed to do. For example, what is the work of WHO, which is World Health Organization? What exactly is the work of IMF, which is International Monetary Fund? What exactly is the work of CCI, that is the Criminal Code? Okay, the Criminal Code, International Criminal Code. This is okay. Then you have ICJ, International Court of Justice. What exactly is the major work of this particular organization? What is ECOSOC? What is UNICEF? And how all of them are working in order to ensure that the whole world does not see World War III. Okay, so international law is also important because majority of the case laws are there, which often asked in your question papers. So we will be going through it, that what is pacta sunda servanda, what is jus cogens, and what are the other provisions, what are the other principles which often are being asked, and what exactly is their use. All of this we are going to start in our upcoming videos. So with this, again, I would like to thank you all for being present and for understanding the video, understanding the concept of amendment of the Constitution. I would request you to kindly revise the provisions of the Constitution and then try to analyze it, that how the questions will be put up in front of you by observing and analyzing the previous year question papers. Once you will gather your knowledge and understanding as to how the questions are being put up in front of you in your question papers, and you try to solve it, you will be able to understand the pattern, and it will be helpful for you to quickly analyze what would be the answer and mark the correct answer without wasting any time, because as you already know that time is the very essence and the key of success in regards to your CLAT examination. So with this all, I would like to thank you for being present, and take care guys.